have to go back a little bit into history for that, because Martin and I go back a long time. Mid-1960s, I became a partner in Freshfields, where I had trained as a lawyer after getting a law degree at Cambridge. And I most liked doing litigation. And so when I qualified, I was put into the litigation department. And in those days, litigation, at least by the city firms, was conducted by really clerks, law clerks, who had no formal legal qualifications, but who were brilliant at following the rules of the court. They knew all the procedures, they knew the judges, they knew the barristers. And very much what happened was that a client would have a case in the court. The law clerks would put the papers together and then hand it over to counsel, who would sort of do the legal input. And I was the first qualified lawyer to work in that department. And so I tended to get the bigger cases. And in 1962, I was invited to become a partner. And I was told that I was going to be a litigation partner. I didn't get any choice, but that was fine. And I think I was probably the first litigation partner in one of the big city firms. I mean, Slaughter May, Haversmith, Linklaters, Clifford Chance, subsequently had litigation partners, but I think I was one of the first. Mid-1960s, and I was doing quite nicely, trying to put litigation under one hat, as it were. The senior partner, Charles Wishaw, who was a very experienced lawyer in oil. He'd acted for Gulbenkian, and he advised the Kuwait government on their concessions. And he called me one day and said, "Alan, I've been invited to advise the government of Kuwait in a dispute with an Italian company, and I would like you to help me and go to Kuwait and see the Crown Prince and find out what it's about." So I went to Kuwait and met the Crown Prince, Sheikh Jabbar, who was only a few years older than I was. And he explained that an Italian engineer had come over to Kuwait and said, "We can build a petrochemical project for the country." And he took a deposit of £7 or £8 million and the Sheikh signed an agreement. And then the government had Danish consultants look at it, Topsayer, a firm which still exists in Copenhagen, and they said it's just not viable. So the government decided not to proceed with the case and said they'd like their money or some of it back. And the Italian company said, "Well, you're breaking the contract," and started an arbitration. And so that was my first international arbitration. Very good panel. It was Professor Argo, who was appointed by the Italians, Lord Shawcross, who was a former Attorney General in the British Labour government, appointed by Kuwait, and Professor Reuter, who became, I think, president of the Swiss Federal Tribunal, was the president. And so that was ad hoc, because all the agreement said was arbitration in Switzerland. And with Chiamenti, the Italian lawyer, I had to sort of put in place all the building blocks for an arbitration. How are we going to get on with this case? We had a tribunal, we had a claim, but how's it going to be dealt with? And so that was a very good learning experience for me. And then at about the same time, one of the corporate partners who became senior partner and a good friend of mine, Hugh Pepian, said, "Alan, I've got a case for a construction company against the government of the Republic of Sudan. And that is going to arbitration in The Hague at the Peace Palace, and I would like you to help on that. So there I was, mid-60s, with a basic litigation department, asked to run to, or to help run to arbitration. And I said to the senior partner, I need another qualified lawyer to join me. He said, we've got this young man called Martin Hunter. He's just been assigned to our corporate department. I'll see if you can borrow him for these two cases. And as Linda said to me recently, that was a loan that was never repaid because Martin stayed with me and the department until he left to become a professor and start his second highly successful career as a professor. And I think you know what a very good professor he was. So that was the background. And then it must have been 1980s, Martin was approached by Sweet and Maxwell, the law publishers, and they said, people are starting to talk about international arbitration, and there's no English book on it. Would you be interested in writing it? And Martin said, I'll do it if Alan will do it with me. And then he came to see me, and I said, you've got to be joking. I mean, we've got a lot of work. We're bringing in new partners, new assistants. We're traveling a lot, both of us, because I was doing a lot of, at that stage, construction arbitrations for the government of Kuwait. And he was working for the Kuwait National Petroleum Corporation. Sometimes the only time we met was when we were both in Kuwait. But anyway, I said, you've got to be joking. And he said, look, we can do it in our spare time. And we can do it at weekends, holidays, and so on. And if we don't do it, somebody else will. So I said, okay, Martin, let's do it. And he was terrific. He said, okay, we're going to have 8 chapters. We're going to go, from the commencement of an arbitration to the award, to the enforcement of an award. That's going to be the structure of the book. And we'll write 4 chapters each. And then you can be sort of editor with all the scripts. And I would deal with the business. He would deal with the publishers. He would deal with translations. That came along later. And he would deal with marketing and all that kind of exercise, because he knew I just liked writing and being a lawyer. And that's how it started. So it was really a call from Sweet and Maxwell that got us going. Yeah, it's changed a lot. I mean, the first edition, which I imagine is my favorite, was quite almost a pocket edition. It was a distillation of what Martin and I had learnt actually doing arbitrations. And as Martin had said, we went from the beginning to the end. We'd read a lot about arbitration. I'd read the Swiss and the French. He'd read a lot of American stuff. But it was a distillation of what we knew. Very few footnotes, and really very practical. And I think people loved it, especially practicing lawyers, because you could get straight to the point without a lot of theoretical discussion. So that was the first edition. And then, of course, it got more complicated. I suppose we ourselves learned a little bit more about arbitration. But also, we were obviously trying to talk about international arbitration. And I suppose the first book was mostly European orientated. And now the aim was to make it more international. And we could only do that because we were partners in a law firm which had offices all around the globe. But it became clear that it was going to be too much for the two of us, and so we would need to bring in 2 people to help us, and that was the first significant change. We had 2 good lawyers, Constantine Partosides and Nigel Blackaby. Constantine has since gone off and founded his own very successful law firm specializing in international arbitration. And of course, he had lots of contacts which were very useful to us. Nigel went to the Washington branch of Freshfields and developed a very big practice in Latin America. And crucially, he wrote what in my view is a really superb chapter on investment arbitration, which was coming along at that time. And so we added, that was one significant change in the book, we added a chapter on investment arbitration. And so it was no longer called Redfern and Hunter on international commercial arbitration. It was now simply Redfern and Hunter on international arbitration. And I have often said to people, if they want a very quick, good guide to investment arbitration, just read chapter 8 of Redfern and Hunter, because that has got it nailed, in my view. And that was, I suppose, as subsequent volumes evolved, they simply got more complex because we had more information coming in from more countries. And the problem is to filter it down, because we want to try and keep it as a one-volume book. Temptation would be to be like Dicey on conflict of law and run into 2 volumes or something like that. But we don't want to do that. And we want the student edition, which is very important to us now, to be something that students can carry in their backpack. So that is quite a struggle because there's so much information coming in. You could write a whole chapter on China, and then we have to put that down to a few paragraphs, which is a pity, but it's the way it's evolving. It was his idea. I mean, he was, as it were, dealing with the business side of this, and he came along and said, look, we ought to have a student edition. And he persuaded the publishers that that would be a good idea. Paperback without any appendices, which cuts down a lot of space. And he said quite rightly that nowadays people didn't need a book with the ICC rules of arbitration or the antitrust rules, because you could get that on your laptop quite readily. And that's what students would do. So we were able to at least cut down the 8 or 9 appendices, which I think the practitioners feel is quite useful. Because if you're in arbitration, it's very nice to have a book that actually has the New York Convention at it, rather than, I suppose nowadays you just project it on screen anyway, but there was a time when it was very useful to have all that for practitioners, but not for students. And so yeah, we produced the student edition, which I think outsold the hardback actually. And Martin had a great passion for teaching. His father had been a teacher at a very prestigious English school, Winchester. And I think Martin had just had that in his blood. You know, Alexander, it's an incredible development. It's a fantastic thing that's happened. I mean, first editions of Redfern and Hunter. I remember going to the law library to chase up references. I went to the British Institute of International and Comparative Law in Russell Square because they had a very good library. If I wanted an English case, then I had to go to the law libraries in the Temple and find the case. If I wanted an international case, I had to go to the British Institute or just ask friends from France, could you please send me a copy of the judgment of the Court d'Appel in such and such a case? And now it's all online. It's incredible. It's incredible. Well, I think the book, there's the Redfern Schedule, which I devised in the year 2000, and that again was a very practical, pragmatic kind of thing. I was on a tribunal with Lord Griffiths, who'd just left the House of Lords and was starting to set himself up as an arbitrator and a mediator. And we were doing an arbitration, and there were three parties, oil companies, and some of them were together on a point, and other points they were against each other. And we went through the usual requests for documents phase. And we got a series of, going back over 3 months, of letters and mails that the lawyers had exchanged. We want to see these documents. We don't have them, or you can't see them because they're legally privileged, or you can see some of them, but not all of them. And this was a changing thing, evolving over the years. Starts off as a big request for document, gets filtered down. And then finally, they can't agree anymore. So they come to the arbitrators and say, make a decision, order or don't order production of these documents. And Hugh Griffiths said, how on earth are we going to deal with this? And I said, Hugh, I suggest we don't deal with it. We let the parties deal with it. Because they've been talking to each other for the last 3 months. They've been writing to each other. They've been meeting. They know what their final position is. So just ask them to set down their final position. 4 columns, Schedule 1, these are the documents we want. Next column, this is why we want them. Answer, you can't have them for this reason, professional privilege, whatever it is, or you can have them, but whatever it is. 4th column, decision of the tribunal. And Lord Griffiths said, oh, brilliant. And then with a wry smile, he said, we'll call it the Redfern Schedule. And that was supposed to be that, and it was supposed to be just for that arbitration. And Johnny Vida heard about it because the bar always chats and talks and spreads information or whatever. And suddenly the Redfern Schedule became, people were saying, we'll have a Redfern Schedule. And I think the high spot for me arrived when Jan Poulsen, and he and I were talking at a conference in Brussels. He said, I just got back from Vietnam, and they've published a book on international arbitration, and look what it says. And neither of us could read Vietnamese, but there was Redfern Schedule, and obviously they were showing how good they were at international arbitration because they could do a Redfern Schedule. And it's gone on, and blame the lawyers who load it too much with requests for documents, and blame the arbitrators who don't say, look, this request is too wide, we're not even going to look at it, for the sort of hard work that has to go. I met a young counsel, and he said, Alan, I spent the last 3 days and nights working on a Redfern Schedule, and I have lost the will to live. And I can understand it. But it's going to be a lot easier, isn't it? Because now it'll be done by artificial intelligence. Some machine will ask the questions much more relevantly than the lawyers, once it's properly instructed, will answer them. And I think the whole thing is going to be a lot easier. There's certainly going to be a lot less demand on people. It's going to be quite a revolution, I think. And we will still need documents, because there are quite a lot of cases, in English cases, in which the judges, who can be a bit tougher than arbitrators, have said, I'm not going to take any notice of this oral evidence because I simply don't believe it. It contradicts the documents, and I will rely on the contemporary documents. And that's quite a movement in the English approach, which has usually been favouring a kind of oral tradition. Martin said the oral tradition was because trials took place in front of jurors, and jurors couldn't read, so the whole thing had to be very much oral. But I think we're getting much more document-based arbitration. So it'll cut down the legwork. It'll cut down all the hours that people have to spend on looking for documents and evidence. Properly run, it could focus the case more on what's really involved. Properly developed, it could help the lawyers put forward arguments that are tenable and not some sort of wild arguments. I mean, a friend of mine who's she's starting as an arbitrator in my former chambers, and she said she's loving it, but she's sometimes amazed at the kind of arguments that the lawyers put forward. Why don't they, select themselves? Well, I remember doing a case with Roger Parker, who was a retired Court of Appeal judge, and there was an American arbitrator with us, and the American lawyer started off his case by arguing something. And the American arbitrator said to him, "Is that your best point, lad?" And the counsel said no. He said, "All right, then move on." and I think we, without the familiarity, you need perhaps something more of that, and more robust arbitrators, I think. We took Nigel and Constantine to a hotel in the country, which happens to be near where I now have a cottage in Sussex. And it was quite a nice hotel. And Martin had said it'd be a good idea to get away from London so that we're not interrupted. And so we sat down in this hotel room, and they started mowing the lawn outside so that we couldn't talk to each other, which was slightly frustrating, but didn't stop Constantine and Nigel agreeing to join us as, first of all, as it were, assistants, and then as editors, with Martin and myself as contributing editors. So that was quite an interesting moment when Constantine and Nigel boarded the ship. I think the best moment, perhaps, with Martin and myself, was not having dinner together on Valentine's Day in a hotel in Kuwait, which was not quite what Valentine's Day was designed for. But when we finished the book, and at the same time, I had bought some land in Savoy, in the town where my wife lived and went to school. But it was on the edge of the forest, and it was building land. And we started building a house there. And 1985, I think it was, the house was pretty finished in the sense that there was a structure. But there was no paint on the walls, and the furniture was mostly orange boxes, although we did have a nice fireplace. And Martin and Linda came over. They drove over from England to join us. And Linda, who's a very good photographer, compiled a book, an album, which she called Finishing the Book. And I think that was a very good memory. And I have some photographs of that, which I hope you'll be able to reproduce. I'd start with the young lawyers, and I'd say, don't go into the law because you think you're going to make a lot of money. Go into the law because you have a feeling that that is what you want to do, because you believe in principles of law. You believe in a society of law. You believe in justice. And that's why you become a lawyer, not to get rich. I think if that is your approach, you're going to be a good lawyer, whatever branch you go into. I would always go into the area that I went into because I think that's just more fun and more challenging. If you get into that area, then certainly you ought to think about arbitration, because that gives you a chance as a young lawyer to get on your feet and argue a case, which is probably what you really want to do. You want to be on your feet arguing. You don't want to be sitting behind somebody else. You say, this is my case, I know about it, and I'm going to present it. And I think with that kind of enthusiasm, you can get there. And if you want to be an arbitrator, then that's quite difficult, because people naturally, and especially if there's a lot of money involved, want to go to established arbitrators. So you've got to be prepared to start perhaps as a tribunal assistant, sitting with a tribunal, taking part in the deliberations or listening to the deliberations, and generally sort of making your name like that. Or writing about it, but I think doing it is probably better than writing about it.